at the moment into the draft bank recovery and resolution amendment as put forward by Jersey's government, which amongst other things is to do with the limits of compensation that are available, but also the transfer of powers from that some of the roles that are currently done by the DCS, the Depositor Compensation Scheme and Board, will be transferring to you. So we're looking to just understand a bit more about that and to see if we can add any value in the scrutiny process to that. This has already been debated in the preliminary stages for first reading, and we're looking at really at the detail of this now. Mm-hmm. Okay, I'll just introduce the rest of the panel. We'll let them introduce themselves. So my Vice Chair.
Good afternoon, Deputy Karen Wilson, Vice Chair of the panel.
My name is Deputy Max Andrews.
Thank you. And if I could just ask for you to introduce yourselves for the record. Thank you.
Of course. Thank you, Chair. I'm Mike Mitchell. I'm the Chair of the Jersey Resolution Authority.
And Martin Edwards, Head of the Jersey Resolution Authority.
Thank you both. But the first thing to say is obviously thank you for coming in, and thank you for the submission that you've given to us in response to the questions we've put out there. So that's all on the public record, and members of the public can of course refer to that. We may refer to that during our questioning today. The first thing I think I'd like to ask you is just to give you the opportunity to explain a bit about what you do, so how you came about, what your current remit is, what the day-to-day activity would look like for you, and the statutory basis that you have before we talk about maybe the changes that are happening to your powers.
Sure. Should I start? I think in general I'll try and answer the sort of high-level strategic sort of questions, and Martin will do the detail. But if it's okay with you, we'll sort of pick and choose a bit in terms of who answers what. But probably I'll ask Martin to carry on from where I start in relation to this. My history is in resolution, so I was in the bank's Special Resolution Unit, the Bank of England Special Resolution Unit during the crisis. So that's the reason why I've ended up in this position. And I was asked to chair the inaugural authority in late 2021, and we set up the authority from 2022. It's fair to say that most financial jurisdictions of a reasonable size have established a resolution authority. Some haven't yet. Guernsey is in the process of establishing one. The Isle of Man has established one now. Bermuda hasn't got there yet. But most of the developed financial jurisdictions have got one. And it was a result of the financial crisis that took place in 2009, 2008 to 2012, and the impact of that potentially on taxpayers. So the whole ethos of resolution is to try and avoid having to rely on taxpayers, the government, to bail out banks as and when they fail. And when you look at history, banks do fail from time to time. The legislation for the Resolution Authority was passed, I think, in 2021, and we were inaugurated on the 1st of January, the 30th of January 2022. And since then, we've been implementing a resolution regime in Jersey. We're probably maybe a half to two-thirds through implementing a series of policies which we believe will help us deal with a banking crisis on the island. We don't believe there's one in the near future, but who knows? Big frauds can happen overnight virtually, so we have to try and be ready for that, even though we're only two-thirds of the way through implementing a regime. But that will give us a number of tools and powers to be able to help deal with a crisis. But I think, as the ministers said at their hearing, the fact is that most of the depositors in Jersey bank with banks that are part of large groups that already have resolution plans in place, and those resolution plans are managed, monitored by the big resolution authorities like the Bank of England in the UK, like the Single Resolution Board in Europe, and similar authorities in the US, Canada, and South Africa, where we have banks operating in Jersey, parts of those big groups. And those big groups have got resolution plans that are pretty well developed and are all designed to try and avoid having a bank get into a situation where it has to go into insolvency, which might then result in a deposit compensation scheme being implemented. So we regard the resolution tools as a really important part of our weapons to deal with a potential crisis. That was one of the reasons why the government, I think in 2016, 2017, decided to concentrate on establishing an authority rather than go through a process of enhancing the deposit compensation scheme. Most of the enhancements of that scheme that were designed in 2016 are in this legislation that I think you approved in principle, didn't you, the government a few weeks ago. I'll probably stop there. I think that's some of the background. But let Martin perhaps mention some of the things that I've missed, and obviously we're happy to take any questions you've got on those points.
I think you've covered most bases there, Mike. Thank you. I think what I would sort of add is that what we've been doing alongside implementing those policies, many of which require banks to take further steps to ensure that they would be resolvable. We've been working to consider the banks in Jersey, consider which banks are most important to Jersey's economy. That involves looking at the size and scale of those banks and the different activities they perform on the island, both for Jersey residents and as part of the wider financial services industry in Jersey. And we've also been in dialogue with home resolution authorities about those plans that Mike mentioned, and understanding those both through questioning home resolution authorities, but also banks locally to understand them and to form an initial view on the level of protection they provide to Jersey. That's enabled us to ultimately help sort of refine our policies, because again, we need to ensure that we're asking banks to do enough, but not being, we need to be proportionate. And if they've done a lot at a group level, they may not need to do as much locally. So that is what I would probably add in relation to what we've been doing since our inception in early 2022.
Yeah. You mentioned that a lot of Jersey banks will have a parent, if you like, or be part of a bigger company in the UK. Are there banks over here which, for whom that isn't the case, and what's your duty of care and concern about those, perhaps? Is that where you really come into play, or is it?
I think we come into play across the spectrum, and we've been very keen to ensure that all Jersey's banks, whether they be branches of these larger banks elsewhere or subsidiaries of the larger banks elsewhere, they've all been asked to do things that help prepare for a potential failure of their group or of their own entity if they are a subsidiary. But to answer your question directly, yes, there are some banks that don't belong to these large banks that we've alluded to, particularly, for example, the large retail banks that we're all familiar with that emanate from the UK. I think it's important to mention that the deposits that they hold, especially the deposits of Jersey residents, are pretty small, and that the vast majority of depositors do bank with the big retail banks that we're all familiar with. But there are some smaller banks, and yes, you're right that we do pay attention to them. They do carry some more risk because of their size and nature, and some of those do not have. They do belong to other groups, but they do not necessarily have as well developed a resolution regime as the UK, as Europe, as Canada, as the US, for example. And therefore they do present a risk to us, that we ensure that we spend time with those banks and probably get them to do more than other banks might be asked to do.
And is it the case, we'll touch on this later on, because one of the areas we're looking at are the limits of compensation currently and what they might be in the future and how they compare with elsewhere. But if somebody when we were doing the outreach work in the High Street the other day said that they thought that they were protected to a higher level because they're part of a bigger UK banking company. And so they told us that they were protected to 80,000, I think they said, which seems like an arbitrary figure. 80 doesn't ring a bell, yeah. But can you clarify that that's under the Jersey system, even if you're with one of those well-known retail banks, you're protected by the Jersey scheme, not by the
Correct.
UK limit?
All the banks that operate in Jersey, and this is common across certainly across developed countries, I was going to say across the world, but certainly across developed countries with deposit compensation schemes, it's common that the deposit compensation schemes are built around the banks that operate in that domain. So yes, every bank depositor in Jersey at any of those Jersey banks is protected up to £50,000. And the 80 is probably a reference to the £85,000 that the UK bank.
And of course, we don't know. Maybe this person had a UK bank account and lived in Jersey. We don't know these.
Yeah.
No, we don't know the
Okay. No, thanks for that.
Typically it's based on where the account is held. So it may be, if it's in a Jersey branch of a UK company, it's covered by the Jersey scheme, not the UK scheme.
Chair, could I just ask, just before we move on, I just wanted to go back to your beginnings, if you like. Are you able to explain for the benefits of the public the difference between what you are and what the compensation board is or was, and why the change was necessary?
And again, I'll ask Martin to jump in. I'm sure he'll have more to answer when we get to the detail. But I mean, essentially, the resolution authority is there to step in. I mean, typically in a bank failure process, we'd find that the Jersey FSC, the Financial Services Commission, will be monitoring very closely the way banks are operating, you know, their capital levels, their liquidity levels, and other aspects of the organisation. And they have a duty to talk to us if they believe a bank is getting close to failure. And at that stage, we would work with them and other authorities, including government and the Deposit Compensation Scheme, in designing and planning what might happen next. And we have a number of powers. For example, we can bail in creditors, so in other words, and we can bail in shareholders. So in other words, shareholders and creditors of a bank can be bailed in to save depositors in the event of us, for example, bundling then up some assets of that bank and selling it to another bank, probably another bank that's represented on the island. The other thing that we do, because most of our banks, as we've talked about, are parts of larger groups, is that we would liaise with the Bank of England. I mean, we have regular calls already with the Bank of England, who would be the resolution authority in the event of one of those big UK banks getting close to failure. And we would work with them, and we already have plans in place for some, not all aspects of the banks that operate here on the island. We would work with them in terms of what's happening next in relation to such a resolution. Probably the Bank of England would bail in those shareholders and or creditors and refinance the group and potentially sell it to another large bank, or they can create a bridge bank, as we can actually for one of our banks here. And all those things would avoid the complete failure, i.e. the insolvency of the organisation. The deposit compensation scheme comes in if those things fail, or if perhaps it's a smaller bank where we don't have the necessary tools, or we don't believe it's critical enough to save it. So we don't necessarily save all banks that fail. You know, we're not in, neither would any other resolution authority. There will be a group of banks that we say, this is not critical to the island. If it was to fail, it wouldn't be the end of the world. And actually, because of, you know, so-called moral hazard, we wouldn't want banks to be saved all the time. So they would be allowed to go into insolvency, in which case the depositors would be paid out under the deposit compensation scheme. So if you like, the deposit compensation scheme is the backstop to this sort of crisis situation. And at that stage, if it were to happen here, then the deposit compensation scheme would initiate a payout process. One of the big benefits of the law that you're in the process of passing is that we have now provided the deposit compensation scheme has quite a slick payout process provided by an outsourced provider that would enable payout to happen much quicker than it would do in the previous law. So in other words, it will initiate a process that doesn't require depositors to claim on the deposit compensation scheme. That information is already fed into the deposit compensation scheme by way of a single customer view. and the deposit compensation scheme can use that information to pay out depositors. That would still be done by cheque in the current environment. There are some deposit compensation schemes looking at digital processes, but they're a lot harder than they sound like they might be if you're actually paying out depositors, especially when they might be located all across the world, as lots of our depositors are. Does that answer your question, Karen?
It does. It was. I mean, it's been very helpful to just understand. I think what we were just trying to establish is, were those functions the same with the compensation board, or is there anything additional to those functions that you as the resolution authority are bringing to the table?
I think the key thing is we definitely have significant additional powers compared to the DCS in a number of areas, and that's by design and standard in other jurisdictions. And Mike's already explained, at the high level, the difference. The combining the two makes sense in Jersey for a number of reasons. Our small size relative to other jurisdictions, it creates efficiency in relation to the number of agencies that banks and government have to deal with. It creates efficiency in terms of some of the operational costs of running two boards as opposed to having one board, etc. But absolutely, we have quite different powers today than the DCS board does. But as a result of the amendments that are going through government at the moment, combining those within us does bring a number of advantages. One of the other key advantages is Mike mentioned that we would be more closely working with the JFSC potentially at the moment in a crisis if it were to happen today. By virtue of that, we'll be more aware earlier in the process, shall we say, and therefore be able to take additional practical steps in relation to banks where we think the scheme might be used to make sure that it's ready from day one, as opposed to maybe ready from day 2 or 3 if in the current situation where there needs to be a level of communication.
Sure. Okay. Thank you. Thank you.
Just on so these should be fairly short questions, but could you advise about the input that you've had, the JRA, in the drafting of this amendment?
We've been involved throughout the process. I've worked quite closely myself with government officials in relation to the earlier drafts of the legislation. And ultimately, we've been working alongside government in relation to framing aspects of that, considering ultimately the detail of how the law is worded, to try and achieve the operational efficiencies that it's designed to do, because it does bring a number of enhancements to the scheme that are very beneficial to consumers.
Could you just tell us maybe a couple of what they are?
Yeah, I mean, the main one Mike mentioned briefly earlier was that it removes the requirement for depositors to apply for compensation. So it brings in a level of automation to the scheme from a legal perspective that allows the existing capabilities that the DCS board have been developing to be used more quickly. So at the moment, depositors would have to apply. That will take a number of days, and then the slick process can start. In the new world, post these amendments, we can effectively start that straight through processing of payments very quickly from effectively day 1, as opposed to waiting a number of days or weeks maybe for customers to apply. It brings a few other benefits, notably the existing scheme has a cap on the maximum amount of compensation that can be paid in total. That is there in partly as a nod to the sort of historic position in relation to the nature of banks that would be used or the scheme might be used for. But ultimately, removing that cap gives some additional flexibility to the scheme. Again, we and other resolution authorities plan to try and avoid significant disruption caused by a bank failure. But ultimately, you can have this scheme as a backstop then that could work potentially even in the slightly larger bank failures.
Sorry, can I just ask as well? Obviously, with you guys, you work for the resolution authority. But when would you usually be notified that there is potentially an issue with a a bank that is potentially going to collapse in its entirety, and how do you then coordinate things with your colleagues internationally?
So that will very much depend on the scenario. Historically, the norm would be that a bank might go through a level of stress, either on its own or because there's general economic stress.
Yeah.
The supervisor will be, and that's the JFSC here in Jersey, and will be looking at that bank slightly more intensively than they would under normal BAU.
Yeah.
And we would actually be notified by the JFSC at that point. Now, at that point, we may not necessarily take many immediate actions, but we would also, like the JFSC, increase our level of monitoring alongside the JFSC. If the bank's conditions deteriorated further, there are a number of steps that the bank would take to try and recover, and that's recovery. And again, we would be monitoring that recovery alongside the JFSC and other agencies in the home jurisdictions. If the recovery actions failed and the bank's financial condition deteriorated even further, again, you just gradually ramp up the level of operation. That's traditionally how it works.
Yeah.
What we have seen in 2023 are some examples out of the US of where that can happen in a very condensed time period.
Yeah.
And ultimately, that's what a number of resolution authorities, ourselves included, are adapting to as a sort of a reality of life. Some banks maybe have business models that might expose them to the potential to fail more quickly. We need to develop our processes, and as do other resolution authorities, to deal with that.
And can I also ask as well, are you confident that you have enough powers in law, should the case be that a bank is in a position where they are potentially going to collapse, where you can make steps to try and intervene, to try and prevent that from happening?
Yeah, I think so, yes. Our legislation mirrors that of the UK and the EU. And we have all the powers that we would expect to have in relation to resolution. Are there some areas where our system is different to the UK? Yes. Our resolution fund is capped to 100 million. 100 million isn't masses of money in terms of a bank size. And that ultimately we have to work within that, which means our resolution planning is different. If in the UK they don't have that kind of a cap, they've got the Bank of England and the UK government behind them in some respects, they can potentially plan slightly differently. But fundamentally, we have the powers that we'd expect to have. Absolutely.
Yeah, no, thank you, Chair.
Maybe I just add, Max, on that you can never have enough powers. Bank failure is pretty scary. Having gone through the crisis in 2009 to 2012, the prospect of one of those big UK banks failing at that time was pretty close to happening, as you will be aware. And this is why resolution authorities have been established and why these powers have been implemented. But even when there have been recent incidents, for example, Credit Suisse, only 18 months ago or whenever it was, the Swiss authorities moved pretty quickly, provided significant liquidity, and was able to manage a process whereby Credit Suisse got dissolved into UBS. But this is tough stuff. So we believe we have what we need, and certainly we're much more confident having these powers than we would have if we didn't have those powers. I was just going to mention on top of that, there are two other things to mention. I think Martin heads up a group, the Bank Resolution Planning Group, which involves government officials, the Deposit Compensation Scheme, the JFSC, and ourselves. And we meet on a regular basis talking about crisis situations. And we did a walkthrough of a crisis just last year, I think, didn't we?
And 23 it was.
At the end of 23. And we've got a number of actions that came out of that. So we are all working much more closely together, I think, than was the case before. And the other thing just to mention is that I think you're probably aware that Jill Britton is on our board. She's the Deputy General of the JFSC. and Martin meets regularly with the supervisors. So we have already an existing process whereby if there are any concerns, even at a relatively modest level, we hear about those in those meetings. So we're able to have the heads up, if you like, without it being a surprise, as in when this bank's about to fail. I think we'll have plenty of notice because of those processes we've got in place.
No, thank you.
Could I just ask about you mentioned the £100 million cap being removed already. Is that affordable, do you think, in terms of what would happen if it's potentially an unlimited cap now, isn't it?
For the deposit compensation scheme, yes.
Go on, sorry.
That ultimately leads to the funding of the scheme, and I think in that respect we've performed some modelling linked to the work that we've done from a resolution planning perspective to identify the banks where this scheme may be used, and ultimately in that regard there's not fundamental concerns there. The 100 million is still reasonable, and by the 100 million we're not talking about a cap here. We're talking about the funding that we get from the state's loan, which is then recovered by way of a combination of bank levies and recoveries from the insolvency. So it's absolutely reasonable in relation to the banks that where it's most likely to be used. The point I made was that by not having it in place, it gives you some flexibility on the banks where you wouldn't want to use it necessarily, but you might need to use it as a fallback. But the reality is, in those scenarios, the scheme would need recoveries from the liquidation to help fund the compensation payouts. And so what we would be doing there as the authority in charge of administering the scheme is looking at the level of funding we do have versus the funding that we need, and then effectively making a partial payment of compensation and waiting to receive recoveries. The level of recoveries needed would vary depending on the size of the bank, but ultimately, by again having the scheme within the resolution authority, we can do more work in the lead up to resolution to identify the likelihood of recoveries and work with the relevant authorities before the failure, but also then work with the liquidator.
Do as Martin says, the big thing about removing the cap is that it gives us flexibility that we can step into the shoes of the depositors and claim from the liquidator in relation to the recoveries that Martin's spoken about, rather than depositors necessarily having to operate.
You're talking about money above the cap at this point, or are you just saying to meet the
above, if it was above the
I'm not talking about. Sorry, I'm talking about the individual. So the claimant to.
No, we're talking about the £100 million total cap, which has been removed.
But when you say to step in the shoes of the claimant, are you talking about the small person who's maybe got £150,000 of savings with that bank? Is it about still protecting the £50,000 they may have, or about making a subsequent claim?
No, it's about the £50,000.
Okay, but you wouldn't be involved in any subsequent claims that somebody has against the bank if there's still money that's left over?
Not normally.
No.
There are one of the other more complicated enhancements that are being made to the scheme is the concept of excess rights, which is effectively the amount that a depositor has above the 50,000. In certain circumstances, that there is the powers in this new legislation, if we feel that the depositor might be prejudiced by overseas law, to effectively vest their entire eligible deposit. So in this example you just gave of someone with £150,000, traditionally today £50,000 is covered, and the remaining £100,000 they would have to claim against the liquidator. In a scenario where if we felt there was rationale to do so, we could vest the entire deposit at the point of bank failure, and that would then mean that we would effectively pursue the liquidator for the full £150,000 and facilitate making payment out to the depositor of the total £150,000. But that is only if there are certain circumstances, and the predominant one is if there was some level of prejudice from overseas law. We need to do some more work around what does that actually mean. But traditionally what that would mean is if there was something in the insolvency legislation for that bank in their home jurisdiction that meant that Jersey depositors were treated, in our view, unfairly. So, it's some more work needs to be done on which possible scenarios that might happen in, but typically deposit compensation schemes have a high level of preference in the insolvency of a bank so that you can get the recoveries and you can fund further compensation payments. And ultimately that's the case in the UK, here in Jersey, and we need to do analysis of all of the home jurisdictions of all of the banks to confirm whether that's in place or where it isn't, when we might then use that extra power.
Thank you.
Do you have any intelligence on it at all at this moment in time?
A little bit, but and ultimately where we see that risk lying predominantly is with banks where we wouldn't expect to need to use the scheme.
Okay.
I just wanted to ask you as well, say if there was a big bank that's headquartered in Jersey, this is where their main office is, how would that differ compared to a bank that might only have, say, a few small branches in Jersey?
So there are no banks that are headquartered in Jersey today.
No.
So hypothetically, it would change things, and we would need to do more work in our resolution planning for that bank by virtue of it being headquartered here in Jersey. The scale of that resolution planning would depend significantly on the scale of that bank.
Yeah.
So if you had a small Jersey headquartered bank that focused predominantly on niche customer groups, i.e., not everyday people on the high street in Jersey, you may need to do very little resolution planning because of, to Mike's point, they wouldn't necessarily be seen as being critical to the island's economy. But if you had a retail bank that was servicing a large proportion of our retail customers on the island, that would be a very different sort of picture. But that's all hypothetical because today all of our banks are headquartered overseas.
Overseas, yes, yeah. The States Assembly passed a proposition. We increased the number of financial conglomerates from 500 to 1,000. This is the top banks worldwide. And so with that probably comes more conversations potentially with overseas resolution authorities. And I just wanted to know whether you are in communication with other resolution authorities and whether that has been component to your engagement.
Developed, and we would have a level of involvement in the consideration of whether it was appropriate for that bank to be given a licence in Jersey, but ultimately that decision would be the JFSC's. And then if it were to set up, then absolutely at that point we would get involved and have the dialogue with the Home Resolution Authority if we hadn't already, because of a lot of these banks will be headquartered in jurisdictions that we already have a relationship with.
And have you looked at international best practice with smaller jurisdictions, for instance, maybe say Singapore or Hong Kong, to see what they have on offer in the case that where a bank were to fail? And has that maybe been something for your consideration in terms of this forthcoming law that's being brought before the Assembly?
Well, both of us attend conferences mainly virtually, although I have attended one resolution conference just last year where representatives of Singapore and Hong Kong were there as it happened. So we do try to learn from best practice. I think it would be fair to say, and I may be slightly biased, but I think the Bank of England's approach to resolution is regarded internationally as one of the best in the world, and therefore in the main, we've tended to follow their principles.
Yes.
But nevertheless, we take the point, and if there are, and I think we would also be bold enough to say that actually we think we've implemented a regime that is probably as good as, if not better than, most smaller jurisdictions. The two you've mentioned, I wouldn't describe necessarily as small in our. They're much bigger than our jurisdictions. But we do look around. Obviously, we've only got limited resource, but we do what we can to ensure that we sort of at the right proportionate level of international standards. But as I say, in the main, we take our lead from the Bank of England rather than from other authorities that we're less familiar with.
Yeah.
Talking of that, is there a special relationship between the UK equivalent of yourselves, so the Prudential Regulation Authority, and the Bank of England? Do they have any interaction other than what you'd expect?
Significant interaction. I mean, I talk with, having worked for both of those organisations. The PRA is actually part of the Bank of England, so
Yeah,
it's a
that's
subsidiary
what I
of the
thought,
bank.
yeah.
So yes, they have a very close relationship. The PRA is very similar to the JFSC, although the JFSC does what the FCA, the Financial Conduct Authority, does, as well as what the PRA does. But the PRA, manages the prudential regulation of banks, building societies and insurance companies, and works very closely with the Resolution Authority, which sits within the Bank of England itself. Yeah.
So if I can move on to, I don't want to dwell on this issue, but one of the things that has arisen from this review and from the amendment is this idea of where the limit should be set. How does government ultimately, and with all yourselves, how do you decide what the limit should be for a compensation scheme, and whether that and how that should change if it ever does?
Yeah, thank you, Chair. And I was going to mention this right at the beginning, and I got derailed in relation to thinking about other things. I know that the limit has obviously been a significant issue for the review that you've undertaken, and we've been speaking to government since their hearing with you about the actions that we would like to take as a result of that, the government and us. And in fact, just in the last 24 hours, I've received a letter from Deputy Gorst formally asking us to commence a review of the limit, commencing in Q2 of next year, subject to the law going through at the end of September. Then our operational plan is that the authority will take over the functions of the deposit compensation scheme effectively at the beginning of the year, but it will take sort of 3 months to complete that process operationally. The deposit compensation scheme has some things it needs to do. For example, it needs to complete its report and accounts and its report to government. But we've been asked, as I say, to commence a review in Q2 2026. We haven't identified what the scope of that review is yet, but we will be working on that with government in the next few months. Government has asked that we don't take our eye off the ball in relation to the resolution regime, because, as I say, we still have got some things that we would like to implement sooner rather than later. But we understand how important this is to you and to the island, and also the Isle of Man and Guernsey, who, as you know, I think have a similar level of limit to what we do. They're also quite keen, I think, to undertake a review of the limit, especially bearing in mind, as you know, the UK is consulting at the moment on an increase from £85,000 to £110,000. So that's not answer your question directly, Chair, but I thought it would be useful for you to be aware of that. I understand the Minister is going to share that letter or advise you about that letter.
Could I ask, I mean, we don't expect the full terms of reference of your review at the moment, but there seems to be an element of chicken and egg in this. So if we look at the statement that was made by the PRA in the UK back in March, so we know that they're in the middle of their review now. But their Deputy Governor and CEO of the PRA said that confidence in the financial system is essential for economic growth, and we want to support confidence in our banks, and that the amount that people can keep in their account, which is covered by the deposit guarantee scheme, moving it to £110,000 per person, would be part of that wider project to ensure that there's confidence in the system. That's very much, if you like, there's a starting point where they're still going to go through their review and their consultation process, but there is a strong lead there that there's a presumption of increasing it because of the cost of living has gone up. Do you think it's valid to have that as a starting point in the Jersey context?
Well, clearly it's been a long time since this limit was set, and therefore it is definitely appropriate to review it. One of the reasons why we've said we want to do a proper review is that there are other consequences of increasing the limit, which is important to a jurisdiction of the size of Jersey. One of the consequences is potentially that the 100 million loan that the government is committed to might not be enough. Probably won't be enough. I mean, it's likely if we increase the limit that there will be an increased burden on government, and that obviously affects the taxpayers of Jersey potentially. So we will certainly want to take that into account. We've also got to take into account the banks who operate on Jersey, who are obviously very important to the economy here, and they will undoubtedly have their say in relation to whether they think an increase in the limit is necessary, appropriate, useful for them. But also they will have a say in as to whether the financial burden potentially of increasing this limit might be a step too far for some of them. And obviously the consequence of banks deciding not to operate in Jersey might be one of the consequences.
Is there a risk that they'll just some will come back and say, we want as low a limit as possible? Is that what they're like?
I think banks, banks, the people who run the banks on the island are typically reasonable people who I think acknowledge that the presence of a deposit compensation scheme and a resolution authority actually are very good things. They're all on board with the merger that we've spoken about, the taking over of the DCS functions. They're certainly on board with that, and I think they will be reasonable in consulting and speaking to them about a review of the limit. And it may well be that an increase is appropriate and relevant. And clearly, consumers with more than £50,000 in a bank account will be keen to see an increase. But we do know that certainly the majority of depositors based in Jersey have balances less than that. We know that from our sort of broad figures, but we need to do more work on understanding exactly how many is it, what impact would it have on those people, where have deposits grown from from 2009 to here. So those are the things, and therefore, how are we going to fund this scheme?
I suppose the difference here, and to understand at what stage Jersey is at, is that when the UK announced their review on the 31st of March, they started off on the premise that it was proposing to raise it from 85 to 110,000 pounds, and then that's what they're consulting on, presumably about how they get to that point and what. So
I believe they started a review internally before that that consultation.
Sure.
So I think they went through a review process in the way that we're proposing to do, i.e., understand the dynamics of the deposit base.
So could you talk us through your milestones that you anticipate how this would work?
Well, we haven't got to that stage in terms of putting those milestones together. I think we know broadly the areas we'd want to look at, but we're very happy to come back to you and outline what we think those milestones are. But literally, because we've been working very hard on trying to get this legislation in place and in good order, and actually I think Martin and colleagues in government have done a great job of actually getting the legislation in good order. We haven't really had time to do that. That's one of the reasons why we said, please don't ask us to do this review yet. We've only got, we had a team of 2 people. We've now got a team of 3 people working on the resolution authority, and they will work.
From your perspective, would it have been helpful if in fact, because I get this is relatively a small part of the bigger picture of what you're doing, but it is something that's politically sensitive and of public interest. So would it have been helpful from your perspective if the government gave a clear steer, maybe did their own review and said, there's evidence that we would like to increase this to a certain amount, and then hand that over to you to fill in the blanks, if you like?
Well, I think, frankly, the government probably hasn't got the capacity or the access to data that we have. And therefore, I think we're probably in a better position to do that review. And, between ourselves and government, we have been speaking about doing this review for some time. But I think rightly, in my view, we didn't want to do it at the same time as this legislation. Because frankly, this legislation, even though it's only about bringing in the functions of the deposit compensation scheme, enhancing some of the schemes we've talked about, and also enhancing some of the existing aspects of the resolution regime, it is still quite complicated stuff. And we only have got limited capacity, both in terms of government, lawyers, and also our own capacity. So we say, frankly, we haven't actually got time to do this review, even if we wanted to. And talking to the other jurisdictions that I think are particularly important to us, because our banks operate on Guernsey and the Isle of Man, they were also in the same place. Yes, we'd like to do it too, but we're also doing this or doing that, and we'd like to leave it probably until 2026 before we kick it off.
Obviously, it's been a very long time since this discussion has taken place about what the threshold should be. And I was looking at the law, and there doesn't seem to be anything that is stipulated for a review to take place every so often. But moving forward, would you be in support of something being brought forward so there is a review, maybe every, say, 4 or 5 years, to ensure that depositors are protected adequately?
Yeah, we definitely think regular reviews are important. In fact, I think the Minister spoke about the corpus of IARDI, the IARDI core principles. Those principles, amongst those principles, they recommend that you do a review at least once every 5 years. I think 5 years is about the right level. I don't think you'd want to do it much more regularly than that.
Sorry to interrupt you. The IRD core principles are amending, and they're actually removing the reference to 5 years.
Okay,
So,
sorry, they are.
they recognise that it doesn't have to be a prescriptive every 5 years do a review, because of that ultimately might not be appropriate. Depending
But
on
regular
what's happened.
reviews, we are
But periodic
absolutely by
reviews
the
should
fact that
be
we should be
useful.
doing
Yes.
that.
Yeah. No, thank you.
I guess in other places there's external pressure. Like so in Jersey, there's this Consumer Council, but who probably don't necessarily focus on financial issues. But in bigger places, there will be pressure groups who are keeping an eye on these things as well.
Yes, although I think we certainly stay pretty close to what's happening in the UK, and I didn't see a lot of pressure building up from consumer groups, for example, on the limit of the compensation scheme, and we haven't seen that elsewhere either. I think we have mentioned in our letter to you that we know the EU did a review of their €100,000 limit a couple of years ago and decided not to increase it. Obviously, it's bigger comparatively than our limit, but nevertheless, it's not necessarily yes, we should be increasing it every time we review it, because there are, at the end of the day, the deposit compensation scheme is there to protect those people who need protection, and there is an amount above which you'd say between 50 and 100,000 or 50 and 150,000. And bear in mind, because depositors can spread their risk across a number of banks as well. But above a certain figure, it's is it really designed? Is this deposit compensation scheme designed to protect wealthy depositors? Answer: no, it's not. Actually, it's designed to protect those people who need protecting. So there will be a limit above which then you'd say actually going that far is not necessary in terms of what we're trying to achieve, and that's what the EU concluded. Sure. We are covering with this €100,000 most of the people, the vast majority of people we believe we need to be protecting. Those people who next week can't.
But this is
can't buy their
we're still
groceries.
way below the €100,000, aren't we?
Yes, we are. Yeah.
And given the fact that the cost of living in Jersey is probably quite a lot higher. But we'll leave that for now because I don't want to get fixated on it.
No,
but
okay.
If I can just finally ask before, I will bring in
It's
Deputy
okay, it's
Wilson,
all right.
but in terms of whether or not the ultimate sum will be, does it have to be, do we have to act in unison with the other Crown dependencies? Because there are, banking presence also in the UK, in Europe and in Gibraltar, presumably, which have different rates.
Yeah, no, we don't. But I think it is important that we go through a process of consulting with them as we go through this review, because actually their banking makeup and the analysis might tell us that they're actually quite different. In which case, I think it's perfectly valid to come up with a different answer. Okay. But I think it's as long as we work alongside them, then I think that's what we'd like to do. We're not necessarily wedded to having the same number.
In Q2, you think it's manageable in terms of the political requests you've had, and you hope that by that stage you'll have done most of this?
No, that's when we're going to start the review.
Yeah, that's right. That's what I mean.
Absolutely.
To start the review.
Yeah.
Yes.
To report back roughly when, do you think?
Well, if to do the job properly, we'll have to take some time to produce information, and that's the thing that we'd aim to do in that quarter. I think realistically we'd be talking about the first half of 27 before we have our review completed.
Okay.
Thank you.
Okay, thank you.
Very patient. Thank
No,
you.
that's all right. Just bring us back to the questions on the functions, if that's all right. We're just interested to explore what you would do, how you would ensure the long-term interests of depositors under the scheme that you would put in place. If some insolvency processes take years to sort of process and be followed through, what will you do in your resolution work or your resolution framework to actually safeguard against that?
So, well, I think I'd start by saying that the core part of the resolution framework is to consider which banks are systemically important and ultimately take steps to hopefully ensure that those banks don't go into insolvency. They may fail, to use that terminology, they may fail, but to use resolution powers to stabilise them and impose the losses on the shareholders without imposing losses on other creditors, depositors. So in that scenario, you're effectively preventing a liquidation of the part that has the depositors. There are complications and nuances where you might let part of the bank go into insolvency, but the idea would be that you protect the depositors and prevent their part of the bank going into insolvency. For those smaller banks where there is not economic rationale of taking all of those steps, ultimately the scheme comes in, and the scheme is predominantly focused about achieving timely payout of up to the £50,000. There is no other element of fundamental safeguarding in relation to the any excess elements. We talked earlier a bit about excess rights and where there might be certain circumstances where those come in. But ultimately, the scheme's focus will be on paying out 50,000, not on assisting depositors that may have more than £50,000 in dealing with the liquidator.
So the scheme won't cover those sort of areas that don't have any guarantees under the scheme. That's what you're saying.
Correct. Yeah. But we would go back to the point that we've made in our letter to you around, a significant proportion of Jersey eligible depositors are with banks that should not, where resolution would be used.
Taking worst case scenario though, what involvement will you have in protecting those long-term interests if something gets to the point of complete failure? Accepting that all of the steps that you're putting in are trying to prevent that from happening, but if it were to happen, do you have any involvement or any?
That would be a scenario where that would be a very bad scenario. It would be a scenario where, say, a large UK retail bank where resolution hadn't worked. I think in reality, you'd potentially be looking at what does the UK do, what does the UK government do in that scenario, because they would be in the same position as us. But let's say absolute worst case scenario, they decide to let that big UK bank fail. Ultimately, we're in a position where we would then be stepping into the shoes of the depositors up to that £50,000 limit. And then we would be pursuing the liquidation effectively on behalf of those depositors. So we would use as much as we can to pay out a partial payment of compensation quickly, and then we'll be spending a lot of their time and effort pursuing the liquidator of that bank, effectively standing in the shoes of the depositors. And that may take time, and ultimately the scheme would run for potentially a number of years whilst that happened.
Yeah, I think that's really what the confidence insurance that's being sought is, that it won't get lost in the moment of time. Are there any scenarios where, for example, compensation may not be paid in relation to things like frozen assets or anything like that? What role would you play in that?
Yeah, so there are, and that's normal for any deposit compensation scheme. The existing DCS board have put in place a process which Mike briefly mentioned earlier, known as the single customer view. So that requires banks to produce a data file that shows their customers in a single view. And that's designed to operationalise a deposit compensation scheme. As part of that process, banks are required to flag certain customers that are blocked for whatever reason, whether that be probate, anti-money laundering controls, which are obviously quite important to Jersey, sanctions, or other court orders, etc. The way that the process then works is that the straight-through processing, well, firstly, with our outsourced provider, we will conduct a number of checks of that data, and as many as possible of those customers will be passed through into the straight-through processing part of the payout. Again, subject to the legal amendments being made, which enable that. The customers that you've kind of referred to there will ultimately step out of that straight-through process and go into separate processes depending on the exact nature. But ultimately, those processes would be a lot more manual. The Resolution Authority, and indeed today the Deposit Compensation Board, would ultimately interface with liquidators of the failed bank and the customer to attempt to resolve those. And that could be missing information, so we can't send a cheque because we don't have your address. Give us your address, prove that it's that address, okay, we'll send you a cheque. It could be that Jersey probate needs to be secured before we can make the payment. It could be a longer term issue, sanctions, as Mike mentioned, that might ultimately mean that we can't make a payment out because the customer is sanctioned, and we would just work with the relevant authorities through that process.
And how confident are you in terms of the cybersecurity protocols that exist here to be able to effect that function successfully?
So we're very alive to the fact that that's very sensitive data, and the existing DCS board with its outsourced provider, are alive to that fact and ensuring that there's appropriate information security controls. I mean, as far as you can be, we're comfortable, and we're in the process of onboarding that effectively for when we take over.
Okay, thank you. That's it.
Thank you. I'm mindful that we're almost at time, and I think we've covered a fair bit of what we wanted to ask you, if not everything. So bearing in mind that we can always follow up with written requests if we need to, I'll just ask if there's any other questions from my panel members.
Just in terms of the £100 million cap again, I wasn't quite sure. I just wanted to get your view as to whether that, for the size of the jurisdiction and the number of banks that are involved, that is an acceptable allocation to run a compensation scheme.
So when you say the 100 million cap, Deputy, do you mean the guarantee, the loan that the government will provide?
Yes, yeah.
Yeah. Sorry, yeah, so the cap is being removed by these amendments, and we see that as a good thing. The £100 million lending facility that's effectively being committed, I mean, assuming no other changes to the scheme, our modelling says that that's reasonable. Clearly, as part of the review that we will conduct next year, if we consider any increase to the level of limit, we need to consider the funding of the scheme, and that's both the loan and bank levies.
Yeah.
So, but as of today, that lending is, is sufficient based on the modelling that we've done.
Okay, thank you.
I did have one final question, and it's something you said earlier about maybe the smaller banks in Jersey which are not part of a bigger group. The difficulty, I think, in the public hearings, I'm not going to mention any names, and I'll be speculating as to what those companies might look like. But I suppose just because there aren't a vast number of Jersey investors or savers, depositors with those kind of banks, doesn't mean that that it's not potentially significant for those individuals in this nuclear scenario. So, is it the case that the Resolution Authority would still work closely with those organisations if they were facing difficulties, and would you anticipate having issues flagged up with you directly?
Yes and yes.
Yeah, because I'm thinking you're the only safety net in a sense for that there isn't necessarily the bigger, in other jurisdictions of a bigger country, of that being flagged up earlier before it gets to you.
No, we're very conscious of that, and yes, we do spend more time probably than is proportionate on thinking about what might happen in those circumstances, and certainly in the event of a failure of a bank like that, then yes, absolutely, we would regard it as our responsibility to try and ensure that it doesn't impact on the stability of the island, and of course, ultimately, the deposit compensation scheme will be standing by to pay out to those depositors to the extent of 50,000 up to £50,000, depending on the capacity of that 100 million we just spoke about.
And do you have any figures currently at the moment about maybe what the depositor landscape looks like in Jersey in terms of who, what the typical
scheme? And it will be, and again, we will, put that aggregate information together for government to see, because I think it'll be interesting for government to understand what that landscape looks like as well.
We will look at the individual bank data and then aggregated data provided to government effectively. I think it's worth noting to emphasise that point about looking at the detail and looking at the data. Another partial reason for ultimately the right timing of this review is that the existing regulations that apply to the DCS board don't grant it massive information gathering powers, whereas we have more extensive information gathering powers. So that creates a complication, and you know, it's also part of the reason why we said to government, let's get this amendment through, let's transfer the responsibilities to the JRA. That gives us the additional statutory remit to go and ask additional questions of the banks and then inform this review.
And is it the purpose of having that constant information to effectively be able to perform health checks, or just be flagged so that you've got, or just so you know what the landscape is that you're...
Yeah, no, we're not in the business of doing health checks. That's something that's in the JFSC's remit. And we wouldn't, we're very conscious that banks have a lot of requests for information from various places. So we wouldn't want to drown them with those requests. But we do think there will be a requirement for us to request some information to help inform this review. So this will be a one-off exercise. If obviously we think it's relevant, useful, necessary, then we will build it into some sort of regular process, preferably working with the JFSC, because they obviously ask the banks for information as well. And one of the things we try to work towards is that we only ask the banks once for one piece of information rather than twice through two authorities.
Just very quickly, you mentioned in terms of the way in which the law is written at the moment, are there any areas, based on what you've just said around powers, do you think the law falls short that you think needs to be reflected in the next reading at all, in terms of your functions?
No, I mean, we've been through it in quite a lot of detail a number of times, and you know, that's not to say that you might not look at something at another time and realise, oh, well, actually that would be useful. But no, what I think Mike mentioned as well, that some of the amendments are to enable parts of our resolution work, and so you know, what we've done there with government is effectively said, look, give additional powers to bring in some additional tweaks in the future. On a more efficient basis, i.e. without a primary law change. So we've taken some steps with government as part of these amendments to facilitate other amendments to help us with our implementation of the resolution regime. And you know, ultimately that's part of our process, which we've been ongoing with banks of consulting on various parts of our resolution regime. And you know, when we get to a point where we've finished that consultation with banks, we can then speak to government about saying, okay, well, let's use that power that these amendments have given us to slot in some additional tweaks to ensure that our regime works more effectively.
And just one final question, Jo. In terms of the accountability, it is the Minister for Treasury and Resources that you take your direction from. External relations.
In the law, yeah.
Do you have any connection with Treasury at all?
We do.
There's a Treasury representative on the group that we talked about before, the Bank Resolution Planning Group. So we always have a representative from Treasury on that for obvious reasons.
Yeah.
Okay.
And the reason for that with the external relations is because that's the responsibility of financial services. Is that right? So it could move potentially if there was a realignment
absolutely.
of that function.
I think it has, over the last few years, changed a little bit, and the law's changed to reflect those changes in the past. But yeah, it's the Minister for External Relations in the legislation.
Thank you.
Okay, thank you.
Gentlemen, if you're happy, we'll bring this hearing to a close, but I will ask if you've got any further points or any questions for the panel.
I think the main point that we would emphasise is that, you know, we will conduct a review. The amendments that are currently being made do bring some significant enhancements to the scheme that will give significant practical benefits to customers if the scheme was ever to be invoked. And so, you know, we really would encourage states members when they debate the law at the end of September, you know, to let's get these amendments through, and then we'll pick up any further refinement alongside our review.
Okay.
Thank you for your time. It's a good process. Thank you.
Thank you, Mr. Mitchell. Thank you, Mr. Edwards, for coming in and